Hello, good morning. Welcome to the last session of the course on the administration of constitutional justice before the equality right. Today we have the pleasure of presenting the translation of the book Essential Elements of Dogmatic of Fundamental Rights that compiles several papers from Dr. Martin Borowsky. The translation was made by one of his students, one of his disciples, who is with us, Arnulfo Mateos Duran. And in these articles, we can see several topics we've seen throughout our sessions, and also other topics that were not included. So I invite you to read the book, to study the book, and in order to start this study of the book, today we have three speakers who will introduce us to the study of this text. First, we will listen to Daniela López Testa, who is professor in Tucuman, Argentina. Next, we will listen to Francisco Mora Sifuentes, who is professor at the University of Guanajuato. Afterwards, we will listen to Alejandro Nava Tovar, who is researcher in the National Institute of Criminal Sciences. And finally, to close this table for the presentation of the book and to close these study sessions, we will listen to Professor Martin Borowsky. Once again, thank you very much to all of the people attending via the social media and also the people who are with us in the auditorium. Each one of our panelists will have 20 minutes. Without further ado, I'll give the floor to Professor Daniela López. Daniela, thank you very much. Good morning. Thank you to the organizers for inviting me and Arnulfo Mateos, especially for this proposal. As we were telling you, we are presenting the book Essential Elements of the Dogmatic of Fundamental Rights. For me, it is very important to be here because I know Professor Borowsky's work, and I had the chance to meet him live during my PhD in Germany and sharing some events as speakers. Professor Borowsky's work is a clear example on how constitutional law is fed from the philosophy of law. The latter produces analytical tips, and constitutional law provides the raw materials to make the analysis needed by the philosophy of law, as any other branch of law. And both branches are very well combined in Martin Borowsky's work. The texts are not only clear, but also the themes covered are quite relevant. And it is helpful for us to interpret the fundamental rights of our own conclusions, and therefore avoid case law and decisions that do not take into account the difference between principles and rules and the consequences. In Argentina, in my country, there's a case law of the Supreme Court of Argentina where judges decide to move away from a role of civil law that is very clear, that establishes the relationship of the creditors in a bankruptcy and treat them as a principle and even balances them. And it is a rule that has all the factual and legal considerations very well detailed, so there's no reason to confuse it with a principle. And nevertheless, it happens. That's why it's important to do these studies, like Professor Borowsky, to have these theoretical differences clear. Also, the topic covered by Professor Borowsky and the principalistic school is quite valid nowadays. And seemingly, the principalistic theory has said everything, but we couldn't find new ideas, and that's not the case. In the German Constitution, a very studied constitution, nevertheless, we can find certain elements, like Article 79, Section 3, but Article 79 in general, that is the reform of the Constitution, and it is a rule because it establishes the conditions on how to reform a constitution by demanding a law, and that law is approved by 2/3 of the parliament. And since it has this clause, it has several principles that should be respected and can't be modified.
Entonces, podríamos decir que este es un artículo híbrido porque si bien es una regla, también tiene este carácter de principio, los elementos que protege este artículo. Y esto trae una particularidad. ¿Cuál es esa particularidad?
It has a specific feature. It happens that in balancing the principle being protected at democracy and some elements of rule of law, the division of branches, it seems that in a balancing it does not proliferate. That is, it's not applied. And that affects the character of rule of Article 79. That's why we say that it's a hybrid, because the rules, of course, should be applied. Otherwise, they would be violated, and in this case, a rule is not applied because the principle didn't overcome the third stage, which is the proportionality test, which is balancing. Today, I'd like to talk about two matters of Professor Borowsky's work. First, I really like his defense of the principalistic theory that is established in one of the first chapters of the book, and the objections. In this case, these are common objections to the principalistic.
Sí, una cuestión de razonabilidad de la teoría principalista y en cuanto a la ponderación. Y gracias a la traducción de Alfredo Mateos Durán, la Academia Hispanoparlante puede tener acceso a este artículo que tiene una calidad muy alta. En segundo lugar, me gustaría hablar también de la transformación de los derechos morales en derechos fundamentales y su obligación del Estado como principal
of the state as the main guarantor, and this is a quite original contribution of Professor Martin Borowsky, and also he talks about the dichotomy,
también conocido como el efecto horizontal de los derechos fundamentales, directo e indirecto. Permítame comenzar con el primer caso. En este ámbito es necesario detenerme en tres aspectos. En primer lugar, el profesor Borowsky no teme a la defensa de los derechos fundamentales como derechos morales positivizados o institucionalizados, cuando en la academia latinoamericana nos pasa que muchas veces, quizás siguiendo la influencia de Hans Kelsen, pareciera que se debe dejar la moral fuera del derecho, que ese es el camino indicado. La escuela es fundada por el profesor Robert Alexis, que es director de doctorado y habilitación del profesor Borowsky, y que es seguido también por el profesor Borowsky, tiene muy en claro que eso no puede suceder porque el derecho tiene un componente moral, tiene una pretensión de corrección. No existe la posibilidad entonces de proclamar que una república se autoproclame injusta, como lo ironiza el profesor Alexis. Si obviamos entonces este componente moral y aceptamos la tesis de la estricta separación entre derecho y moral que postula el positivismo, nos quedamos sin parámetro para criticar el derecho positivo y para negarnos a aplicar el derecho extremadamente.
Refuse to apply that law is extremely unfair. And Professor Borowsky has this component of corrections that implies a legal duty to consider moral principles. Another objection of Professor Borowsky is the irrationality that could take place with balancing the last degree of the proportionality test. In this sense, the author
que la ponderación permite tomar la decisión relativamente más racional de los problemas normativos, acá cito, en el mayor nivel analítico posible hasta este momento. Y es que erróneamente se piensa que los argumentos no serían racionales, los argumentos aportados a la ponderación, cuando en realidad la teoría principalista justamente trabaja de la mano con la argumentación jurídica, y de allí deriva esta exigencia de razonabilidad de las decisiones esgrimidas para justificar las restricciones de los derechos fundamentales. Tampoco se puede temer que un juez incluya en su examen cualquier principio que invente o que cualquier norma que invente su carácter de principio, porque estas siempre serán constitucionales o provenientes de la ley de acuerdo a qué grado tengan. Y tienen una validez determinada en un ordenamiento jurídico. Eso es otra de las salvedades por las que no se puede acusar de falta de racionalidad a la ponderación. Otra forma de evitar esto es la exigencia, que lo pone muy en claro el profesor en este artículo, la exigencia de que lo decidido del juez se concatene con lo decidido anteriormente, con lo decidido en el precedente y con lo que se vaya a decidir en el futuro. Aquí se ve una clara referencia del autor al trabajo de Ronald Olguín de la lectura moral de la Constitución y su idea de que las decisiones judiciales no son aisladas, sino que la labor de la jueza se va a concatenar con las interpretaciones de la Constitución que se hicieron anteriormente, que se harán en el futuro, como si de la escritura de una novela se tratara, una novela colectiva en la que intervienen los distintos jueces. Entonces, cada juez debe encajar, utiliza el autor la palabra, su comprensión con la lectura de la Constitución. Esto lo hace en su lectura moral de la Constitución en su obra. Entonces, finalmente, voy a reparar en la propuesta de Drittwirkung, producto de los derechos frente al Estado, del efecto horizontal de los derechos, que es una teoría en cuanto a productos de los derechos frente al Estado que elabora el profesor Borowsky. Como les decía, ella es superadora de los dos enfoques de Drittwirkung imperantes hasta ahora. Su Drittwirkung se centra en la figura del Estado. Recordemos que la teoría alemana de la eficacia horizontal inmediata de los derechos fundamentales, también conocida como unmittelbare Drittwirkung, fue defendida por Karl Nipperdey y fue tomada por el Tribunal Laboral Federal en cierta medida influenciado por este. Para esta teoría, los derechos fundamentales valdrían no solo frente al Estado, sino también entre los particulares directamente. Una alternativa a esta teoría es la construida por Günther Dürig, es de la Drittwirkung mediata o indirecta, que entiende que si bien es el Estado el que está obligado a respetar los derechos fundamentales de los individuos, ellos irradiarían su efecto en las relaciones entre particulares. Ello produce que los conflictos entre individuos, por ejemplo, en el derecho civil, se deban resolver con normas del derecho civil, pero a la luz de los derechos fundamentales. En este caso no serían los particulares los que están directamente vinculados a los derechos fundamentales, sino que es el Estado, representado en la persona del juez, quien debe respetarlos y garantizarlos en sus sentencias. Entonces aquí se da una especie de asunción judicial, es decir, se imputa la lesión de un derecho no al particular, sino al Poder Judicial por su complicidad o simplemente por su pasividad ante una violación de los derechos. Con esto no se quiere decir que sea el Poder Judicial el que está violando el derecho, sino que él es culpable de alguna manera por no remediar la situación de violación. Justamente por esa asunción judicial, un tribunal superior puede rever la aplicación que hizo el juez inferior de los derechos fundamentales en el caso civil, por ejemplo. Esta posición fue aplicada en Alemania en el fallo Lüth del Tribunal Constitucional Federal Alemán, Bundesverfassungsgericht. Allí se habló de un orden objetivo de valores. En cuanto a la teoría construida por el profesor Borowsky de la Drittwirkung producto de los derechos frente al Estado, se puede utilizar para entenderla el ejemplo del derecho internacional de los derechos humanos, para tratar de comprender cómo funciona. En este ámbito, en el de los derechos humanos, solo pueden ser demandados los estados, no los particulares. El Estado va a ser el centro de imputación, es en quien recaen los deberes de protección y de defensa de los derechos fundamentales. Pensemos, por ejemplo, en el caso del derecho internacional Fontevecchia en Argentina. En él se discutía el derecho a la privacidad versus el derecho a la libertad de expresión y de prensa. Una revista perteneciente al editor Fontevecchia había publicado un artículo sobre un hijo extramatrimonial del expresidente Carlos Menem de Argentina, y por lo tanto se condena en el país a Fontevecchia al pago de una indemnización. Este editor acude a la Corte Interamericana de Derechos Humanos y demanda al Estado argentino, no a Menem, por el incumplimiento de la protección de la libertad negativa, como lo es el de la censura y de la libertad de expresión. No es que la tesis del profesor Borowsky esté pensada para el ámbito internacional de los derechos humanos, pero allí se puede entender mejor su funcionamiento. Esta idea también puede ser contrastada con lo que ocurre en nuestros países. Como operadores jurídicos, tenemos el deber de utilizar este tipo de teorías para mejorar la comprensión de nuestro propio derecho. En Argentina, por ejemplo, si uno quisiera saber cuál teoría del Drittwirkung tiene acogida, se encuentran algunas dificultades. Quizás en sus países pasa lo mismo. Es que existen ciertas tensiones en el derecho local entre al menos tres cuestiones. Por un lado, el amparo de derechos constitucionales, que sería una especie de tutela de los derechos fundamentales, permite accionar contra particulares, en una suerte de Drittwirkung inmediato, como si los derechos fundamentales tuviesen efecto directo dentro de las relaciones de los particulares. Por otro lado, el recurso extraordinario para acceder a la Corte Suprema de Justicia de la Nación posibilita rever si la sentencia del Tribunal Superior de la causa ha lesionado o no derechos fundamentales de las partes. Y ahí parecería que Argentina tiene vigencia en Argentina tiene vigencia una especie de Drittwirkung mediato. Finalmente, el artículo 1 del Código Civil y Comercial Común argentino establece lo que algunos autores denominan un diálogo de fuentes, a semejanza del desarrollado por Eric James del Instituto de Derecho Económico y Empresarial de Heidelberg. Él lo desarrolla dentro del derecho internacional privado y esto permitiría una aplicación directa, así lo entienden en Argentina, del derecho constitucional y del derecho de los derechos humanos. Como ven, existe una cierta confusión en torno al tema y parecería que se adoptan varias posibilidades de Drittwirkung al mismo tiempo. Entonces, a causa de estas idas y vueltas, este efecto pendular, existe una confusión importante, tanto la doctrina como la judicatura, que debe ser aclarada para ganar
judiciary that should be
y lograr
clarified and to have more previsibility. Now, I'd like to out some conclusions as a thesis. So the topics covered by Professor Borowsky is quite relevant. That can be used to interpret the fundamental rights of our own constitutions and therefore avoid case law with the proliferation of judgments that confuse rules with principles. Also, the principalism theory of law has full validity. Seemingly, everything has been said by the principalism theory, but there are certain elements that imply unanalyzed complexities. An example thereof is the German Constitution, Article 79, that includes patrial cause, and this is a hybrid case. It contains the factual and legal determinations that are very well detailed, and the elements that protect the patrial clause are principles. And these two characters might cause the rule not to be applied. He also presents common objections to the principalism theory. He talks about an article, Borowsky is not afraid to defend fundamental rights as moral rights. In the Latin American academia, there's certain reluctance to recognize a moral character in law, perhaps following Kelt's theory. Balancing allows to make the most rational decision of normative problems at the highest analytical level. This is something Professor Borowsky makes clear, and this is a great contribution to face these objections of principalism. As Professor shows, arguments could not be rational when, in fact, the principalism theory goes hand in hand with legal argumentation. To justify the restrictions to rights. Another way to avoid this demanding judges that their interpretation is linked with what was decided earlier, and if it's going to move away from that, it should be well-founded. And the theory of Professor Borowsky of the transformation of moral rights into fundamental rights, the obligation of the state as the main guarantor, is an original contribution of the dichotomy. I recommend this book. Personally, it is a great book full of very important articles to keep on building on constitutional law nurtured by the philosophy of law that comes from Professor Borowsky and Robert Alexi. Thank you very much for your attention, and I congratulate the collaborators of this work. Daniela, thank you very much. Thank you for accepting being with us from Argentina remotely. For sure, we will have the chance to work in person. Next, we will listen to Professor Francisco Mora Sifuentes. Professor, you have the floor. Hello, good morning, ladies and gentlemen, those who are with us in person, and of course, those who are following us through the social media of the Center for Constitutional Studies. I'd like to acknowledge the Center for Constitutional Studies, of course, the Supreme Court of Justice, and Ana María Ibarra for being today with us. I am very pleased to be in this venue and essentially being able to share the table and the presentation of this book with my dear colleague, Dr. Alejandro Nava Tovar, and with Daniela López. I haven't met you yet, but obviously, as she said, they are experts in the principalism theory of rights. Of course, I thank Professor Borowsky for everything he has done for me and essentially for sharing with me his knowledge. I think that I should also mention the work done by Arnulfo Mateos, who is the editor and the main translator of this book. Indeed, we should celebrate this work because, as Daniela said, a great Spanish-speaking audience now has access to this work, and we can keep on learning and discussing with them. Having said this, I'd like to structure my presentation into main parts. Daniela made a very technical presentation, and as you could see, in fact, it is complex and difficult to present a book like this, and especially with its dimensions. This is because of the content and the extension, and some sections are very technical and dense. However, I'd like to share with you some suggestions or make a sort of invitation to read it, because why should you read the book? To this end, I'd like to provide you with the same keys that I used to approach the book. What can we find in the book? I think first we should highlight that this is a compilation of works. Even though they are not planned to form a unit work, they do have an organic sense and finality. The book, for sure, is the analysis of the dogmatic study of fundamental rights by the author. In these works, as it has been said, some ideas are modulated or deepened that at least we can trace back from Professor Borowsky's book, his PhD thesis, Fundamental Rights as Principles, a work that at present has reached its third edition. Secondly, I think that the best way to approach this book and this work is starting from the prologue written by the author and the introductory story by Arnulfo Mateos. Indeed, the key to understand the works included there is this prologue made by Professor Borowsky. Somehow, the prologue summarizes the vision of fundamental rights that he uses. What are the keys that he points out? Firstly, the idea that fundamental rights are positivized moral rights, and this is important because he says that the category of human rights, for instance, shouldn't be used to refer to human rights, but rather talk about conventionality. For him, human rights are moral rights, or there's a strong moral justification. Secondly, the thesis of the binding force of fundamental rights. They are contained in legal norms that are binding or directly binding. Number three, he makes a distinction between purely objective norms and subjective rights. Obviously, this is the case because fundamental rights as constitutional norms or conventional norms that add a legal or procedural position means that in subjective rights, people may have the legal power to implement certain position before the courts. And finally, rights understood as prima facie positions. This has to do with the fact that a theory of rights as principles, and then we have the articulation. So for Professor Borowsky, a fundamental element, and I'll talk about that later, is indeed that when we analyze and we study fundamental rights, bearing in mind this analytical dimension, because if we start from these considerations, it is much easier to discuss in an orderly fashion the problems that stem from fundamental rights, and especially have a minimum clarity that will allow us to identify how problematic are the difficult cases, so to speak. This work, I insist, includes many works. I'd like to mention two specific ones. Daniela already mentioned the text of the Triplicum and the fundamental contribution, that is the articulation through the positive duties of the state, and how this integrates and overcomes the traditional theories or the constructions of the direct effect or indirect effect of the immediate construction. I'd like to mention two works. One of them is the triumphant march of proportionality. This is a very interesting work because we are given clues on the origin of proportionality in German law, and above all, how the idea of proportionality has achieved its position nowadays as an adequate theory for fundamental rights in the legal provisions of democratic countries. So in this specific text, I think that the fundamental thesis, or the most important thesis, is the idea that if proportionality and the theory of principles and legal argumentation, etc., has achieved such expansion. There was a quote that I like to use a lot, a product of legal export from Germany. So if it has that quality, it is because proportionality has an analytical structure that can be universalized. That is, if proportionality has achieved that triumphant march, it's because It is a technique to apply rights, and obviously with that the theory of principle from Robert Alexi, if it has had this reach, is because of this analytical aspect. For sure, the analytical aspect is the most important one, and anyway, in this work, there are other discussions that have to do with the aspect of the philosophy of law and the theory of law that are involved in the idea of proportionality that Daniela explained. A non-positivist theory saying that human rights are moral rights is very suitable for a positivist theory, and fundamentally the defense of practical rationality. So I think that this work is very suggestive because he talks about the origin of proportionality and the reasons why it has expanded. Another work that I found interesting, I insist, I'd like to give suggestions or make a sort of invitation to read it, is a chapter about the subjects of constitutional interpretation. In this work, Professor Borowsky makes a defense or uses a broad concept of interpretation, but this concept should be understood in the sense that not only the Constitutional Court is the one that has power or authority in constitutional interpretation, but also and fundamentally the democratic legislator and the specialized courts. In this sense, there's a very interesting analysis and critique to Peter Aberle's thesis, the thesis of Open Society of Constitutional Interpreters, and seemingly, according to Professor Borowsky, is very ambiguous, and somehow an essential aspect is lost, and it is that in a broad sense, we can say that people, individuals, have a self-understanding of their fundamental rights. However, this self-understanding of fundamental rights or that interpretation does not make them automatically or doesn't make this interpretation a constitutional interpretation, fundamentally because it doesn't have the authoritative implications that are involved in the aspect of the other interpreters mentioned, like the Constitutional Court, the democratic legislator, who's attached a great importance, and fundamentally other specialized courts. I think, and with this, I'd like to wrap up. I don't know if it's too risky to say this, but in my opinion, Professor Borowsky's work is one of the most developed in the theory of principles. And why? One of the most developed, because at least regarding the doctrinal work, that is, in his work, he shows a very profound and intense doctrinal work, and in this sense, it is the most dogmatic of the theory of principles. The author that has focused more on the dogmatic aspect of rights, systematization, interpretation, reformulation, critique of the application of the theory by the courts, and the reception of the theory. And I think that the limited control in the balancing of fundamental rights can be used as an argument or justification to what I'm saying. In this book of essential elements, we are offered the pieces of an adequate theory of rights. That is, a theory that offers a reconstruction of the functions that rights have in the framework of constitutionalism. It's a structural theory of rights that is in conditions to articulate different functions associated to them, fundamentally to give room to the different types of rights that we can identify in modern constitutions or broad categories of the rights of defense, the equality rights. And obviously, this is seen in the work that the theory leaves a necessary margin so that the authoritative character are not diluted in the framework of constitutional rights. There's an idea to keep the deontological margin of rights, and especially here, the issue is that this can be articulated through a theory of fundamental rights as principles. So with this, we give rights its ideal dimension, and this is the aspect behind the articulation. Definitely, I think that in such a dynamic society like ours, where the Supreme Court should be the interpreter and the fundamental actor to guarantee fundamental rights, the contributions to the theory of fundamental rights made by Professor Borowsky can be a very important tool so that the activity of the courts are controlled. And in this sense, it should be as rational as possible with the tools and instruments that are implicit here in the theory of argumentation, etc. Well, this is everything I have to say, and I'd like to thank you, and I really recommend, not as a class of style, to buy the book and read it. It will be certainly well invested time. Thank you very much. Thank you very much, Francisco, for presenting this map to navigate Professor Borowsky's book in all its nooks and crannies and the approaches to some aspects of its articles. Thank you very much. Next, we are going to listen to Alejandro Nava Tovar. Alejandro, thank you very much. Good morning, ladies and gentlemen. I'm very happy to be here with you. I'd like to thank the Center for Constitutional Studies and the Supreme Court for the invitation, especially Ana María Ibarra and Ana Cristal for the invitation, especially because I'm not only meeting Daniela. Arnulfo had already talked to me about you, but also being with Francisco, but also because I meet an old friend of mine. He has a busy agenda in Mexico, and now I have the chance of presenting his most recent book in Spanish, Essential Elements of the Dogmatic of Fundamental Rights, which was translated by a good friend of mine, Arnulfo Mateos. I'm going to start. Francisco and Daniela have explained important details of this work. So, with respect to the current peak of proportionality tests in constitutional law, legal argumentation, and the philosophy of law, it can be said, paraphrasing the famous beginning of History of Two Cities of Charles Dickens, what happens during the best of times and the worst of times. On one hand, this exam is living the best of times because it is quoted by numerous constitutional courts as a sign of a sophisticated argumentative exercise and doctrinal knowledge. On the other hand, this exam is living the worst of the times because today, more than ever, there are several misinterpretations about its nature, which say that this exam justifies judicial discretionality. The bibliography about this test is quite extensive, even though most of the works in Spanish are based on indirect references or have a lot of ideological biases, quite a cognitive apocalypse. This way, very few people are specialized on the theory of principles, and they include the study of proportionality hand in hand with the study of the dogmatic of fundamental rights, whose objective is to study the positivization of liberties in legal instruments with its subsequent application by the jurisdictional bodies. For this reason, the conceptual clarity regarding its scope and reach is fundamental. In this context, the work that we present from Professor Borowsky, entitled Essential Elements of the Dogmatic of Fundamental Rights, is an extraordinary effort to understand the importance of the dogmatic of fundamental rights. Indeed, these rights are part of a commitment from the executive, legislative, and judiciary branches with rule of law. So that's why we have a book this size. And finally, I'll talk about Arnulfo's translation. It has 11 chapters, an prologue, and a detailed introductory study of the translator. The 11 chapters of this book cover 2 decades, where we can see a development from the theory of human rights and fundamental rights from Professor Borowsky. Professor Borowsky's work is strongly influenced by the thought of his professor Robert Alexy. Nevertheless, in the last decades, Professor Borowsky has enriched the theory of principles, the principalist theory, with reflections on human and fundamental rights, which can be seen fundamental rights can be seen as principles, and in this set of essays that are now available for Spanish-speaking audience. In the several essays of this work, there are 4 distinctions that link the several essays to it: the distinction between human rights as moral rights and the respective instruments for their protection, the rights guaranteed by legally binding rules, the objective rules and objective norms, and the fundamental rights, constitutional and conventional rights as prima facie positions and definitive positions, or absolute and relative rights. These 4 distinctions are connected with several concepts of the dogmatic of fundamental rights, concepts that allow us to understand the differentiation between absolute or definitive rights and relative rights or susceptible to restrictions. And therefore, Professor Borowsky explains key concepts of dogmatics, such as the scope of protection with its personal material scopes and the restriction of fundamental rights. All these topics are treated with rigor. The nature of fundamental rights demands a work of constitutional law and philosophy of law. Martin Borowsky certainly is a specialist in both subject matters, philosophy of law and constitutional law. Next, I'm going to talk about the key topics of these essays. I had to stay up all night. The first essay, entitled Principles as Norms of Fundamental Rights, makes a distinction between rights and principles. And now, listening to Daniela, I see that this distinction is something that is misunderstood in our Latin American tradition. Daniela, I've heard something like that in Mexico. And the respective objections of Michaela Percha, which are many, and they are interesting. Nevertheless, After this development made by Borowsky of the backflash objections, he says that those objections can be invalidated because an adequate reconstruction of fundamental rights is only possible through a principalism model. But it's good for the Spanish-speaking audience knows these objections. The second essay shows the German dogmatic of the fundamental rights around the scheme of restriction intervention. Through 3 detailed sections, Borowsky synthesizes the fundamental right in the exam of the control of constitutionality and the respective ways of constitutional justifications of the interventions in fundamental right in the exam of control of constitutionality. This section is a rich and deep contribution to the explanation of the forms to intervene or restrict fundamental rights, according to the same structure of fundamental rights and the principle of proportionality. That leads us to the next section. The third essay, entitled The Triumphant March of Proportionality, is one of the most important chapters of the book, I think, by virtue that it exposes the fundamental structure of the proportionality test, its insertion in German law, and subsequently in international law. Here, the title about this triumphant march, I think, it alludes to a confrontation about the triumphant march of proportionality. Besides, Borowsky links this exam to constitutional and philosophical issues, providing the public with a comprehensive understanding of this exam, of this test, despite of the attacks to proportionality, as Daniela said, that are too many. Borowsky concludes that the triumphant march of proportionality will continue its course. I have a similar opinion about this triumphant march. The fifth essay gives rise to the systematization of themes of the German dogmatic of fundamental rights. This essay presents the several functions of fundamental rights upon the tripartite division between the rights of defense and the rights of provision and their relationship with the equality right. In this sense, the sixth essay develops the so-called prestational fundamental rights. He makes a first distinction between fundamental rights of equality and defense. And then within the prestational rights, he makes a distinction that was also popular by Alexei in his theory of fundamental rights between the rights of protection and the right of organization and procedure, and finally social rights. The seventh chapter, mentioned by Francisco already, develops the foundations of the constitutional interpretation and its interpreters, like the German Federal Constitutional Court and the legislative branch as interpreter of the Constitution. The eighth chapter exposes or shows a very important topic related to balancing fundamental rights. With this objective in mind, Borowsky explains the instances of the limited control and its characteristics when balancing fundamental rights. And then he develops 2 basic questions of the theory of principles, to wit, the weight formula, which is always a headache, and the concept of formal principle, which is one of the most complicated issues nowadays in the principalism theory. It is quite complicated, and I'd rather not say anything about formal principles. I hope that Professor Borowsky's contribution sheds light about this complicated issue. I repeat, I don't want to know too much about this. The 9th chapter is related to something Daniela and Francisco said, which is the horizontal effect of rights, and a work that has been developed by Francisco, and he has reflected on this. The 4 previous chapters will give the reader an explanation of the dogmatic of fundamental rights, and this is important because A short time ago, I was listening while a Spanish professor said that we have punctuation because, unfortunately, we've lost the importance of the dogmatic of fundamental rights. And Professor Borowsky's works is a rebuttal of those ideological biases. In fact, it is a necessary connection, as necessary as the connection between law and moral. But we always listen to this idea of ideological biases. The 10th chapter is one of my favorite ones because it offers a discussion around what Daniela was saying, the philosophical foundation of human rights. In fact, when I was introduced to Alexis' thought, this was mediated by the ethical of discourse developed by Karl Ochoapel and Johann Habermas. In this sense, the famous essay of Robert Alexis called Theory of Discourse and Human Rights was the first way to approach Alexis' work. Here, Borowsky is based on the theory of discourse developed by these mentioned authors. But something interesting is that it is developed in the context of international law, which could be interesting for several moral and political philosophers interested in the discourse of human rights. With this idea in mind, Borowsky shows the concept and characteristics of human rights and connects them with the basis of the theory of discourse to show how such theory of discourse allows to found human rights that point to their universalization. And it's very important to talk about this in the Latin American context, where sometimes falsely the thesis of the universalization of human rights is criticized, like with Daniela's thesis and the positivist thesis, or even thesis in the field of philosophy about postmodernism or moral relativism or colonial thought. The 11th chapter talks about the theory of post-sovereignty that is recognized. He's recognized as a specialist in legal argumentation, but his political writings are not well known. Here, Professor Borowsky extracts several arguments of McCormick's theory of post-sovereignty and says that said theory represents to date the most sophisticated attempt of explanation to overcome the simple confrontation of the European perspective on the national vision of the European Union. Said legal reconstruction from McCormick lies in the analysis of the concept of sovereignty and the conception of legal pluralism, which, despite its virtues, Borowsky says it's insufficient to reveal the nature of stemming from community law and the national law. Nevertheless, McCormick makes an effort to reconstruct the concept of community law. The last essay makes a brief description of the normative supremacy of the law of the European law. To make this reconstruction, Borowsky appeals to the theory of formal principles to determine the primacy of said right. The systematization exposed in the book and the clarity that we can see in each chapter and the detailed bibliography constitute an effort that should be mentioned in the contemporary discussion in our language. The previous arguments allow me to recommend the thorough reading of this book. Now I'm going to talk about Arnulfo's translation. Translating is difficult. Translating from German is quite difficult. Unfortunately, I know that. But recognizing the work of translators is something that is unimaginable. I remember that in the English version of the concept of the validity of law of Alexis, when he talks about the detailed translation of Professor Stanley Paulson and his wife Bonnie Paulson, said that the process of translation allowed him to see that translation is essentially interpretation. During that translation, I could see Arnulfo's effort to interpret Professor Borowsky's work and delve into the knowledge of the dogmatic of fundamental rights, which shows Arnulfo's effort, and at least for me and Francisco, meant a lot of work. That's why I haven't complained yet. Well, Arnulfo, I really congratulate you for that translation. I learned a lot from you, and you really raised the bar for translations. Congratulations. I'm going to finish with this. The constitutional dilemmas stemming from the conflict between fundamental rights happen every day. They are part of the experience of local and global constitutionalism. In this context, the proportionality test is here to stay, as Martin said, as an interpretative method to solve these conflicts and waiting to be subject of study from those who live this experience. But using casually this principle, it will bring more benefits than problems. After all, balancing the use of the proportionality test is just another sign, unequivocal sign of its rationality. Thank you very much. Thank you very much. Next, we are going to listen to Professor Martin Borowsky. This is the last intervention in this table of presentation of the book, Essential Elements of the Dogmatic of Fundamental Rights. And this is his last intervention during these days we've had on this course, and we have learned so much from you. Thank you very much, Professor Borowsky.
Thank you. I shall thank Ana María Ibarra and Diana Gonzalez for making this splendid event here today and over the last 2 weeks possible. And of course, thank you also for 3 amazing interferences. I had the honor to listen here just. The papers in this book were written as independent articles and chapters in edited collections over the last 2 decades. They contain essential elements of my theory of human and fundamental rights. This theory is based on 4 key distinctions, Francisco Mora already mentioned them, which are reflected in and presupposed by the papers in this book. The first distinction is between human rights and moral rights and legal instruments for the protection of human rights. It undergirds the second and the third distinction. The second distinction between rights that are granted by norms that are legally binding and norms that are not legally binding. The argument from effective enforcement calls for the transformation of human rights into legally binding norms. What is more, the argument calls for transformation into subjective rights rather than merely objective norms, which is the third distinction. Finally, the fourth distinction is between constitutional rights or convention rights as either prima facie positions or definitive positions. One ought to distinguish between human rights as moral rights and legal instruments for their protection. Human rights were developed in the writings of the Enlightenment from the 17th century on. More recent approaches to justifying human rights include John Rawls' A Theory of Justice, Robert Nozick's neo-libertarian entitlement theory, and more recently, John Griffin's approach based on personhood and side constraints he calls practicalities. These human rights are justified by means of philosophical methods. They are moral rights. Every human being can claim everywhere that any other human being has violated a certain human right by means of an action or omission, provided that such a definitive moral right to an omission or action can be justified by means of moral argument. Whether such right has been authoritatively issued by a national assembly in the form of a constitutional provision or has been agreed in an international treaty protecting human rights is simply irrelevant for the existence of the moral right. A moral right exists if there are convincing moral arguments on behalf of this right. Moral validity is based on moral correctness and on nothing else. Such rights need to be distinguished from legal instruments for their protection. Rights granted in constitutional provisions or provisions in international human rights treaties are legal rights. They have legal validity owing to having been authoritatively issued and being socially effective. Unfortunately, as already been mentioned, there's a tendency to obscure this distinction by calling legal instruments human rights, such as in the European Convention or the American Convention on Human Rights. Following the distinction just explained, these conventions actually do not justify or give rights to human rights, they positivize legal instruments for their protection. While human rights as moral rights are rights erga omnes, constitutional rights or convention rights are rights against the state and have only indirect horizontal effect. Since legal rights are part of the law, they can be enforced by means of coercion. Even though human rights as moral rights and legal instruments for their protection ought to be distinguished, there is a close connection between those two kinds of phenomena. If a legal right is recorded in a constitution and corresponds to a human right, as a moral right, then this constitution transforms this human right into law. This process of transformation is not morally contingent, rather, there is a moral obligation for such transformation. There are two key arguments on behalf of such transformation, and this is the argument from authoritative cognition and the argument from effective enforcement. Even though there is a great deal of consensus that a certain core of fundamental interests of the individual is morally prima facie protected, it is fiercely contested which rights are actually human rights and qualify, therefore, as rights that ought to be transformed into constitutional rights or convention rights. What is more, there is often not only a single right answer in balancing competing human rights under the circumstances of the case at hand. This is to say that our cognition of moral correctness is limited, so that substantive cognition of what human rights require needs to be complemented with authoritative cognition. Legal authorities, the parliamentary legislator, and courts are established and vested with the legal power to assess claims stemming from constitutional rights, with authoritative force. What is more, moral rights do not lend themselves to effective enforcement, has already been mentioned, and so the substantive content of human rights needs the form of law. After the transformation of human rights into constitutional rights, the latter will be enforced as part of the law by public authority. Legal documents, such as constitutions or parliamentary statutes, usually provide for norms that are legally binding, namely, norms the violation of which can be established by a court. The finding of a violation of such norm by a court will usually imply enforcement measures. For example, that a parliamentary statute that violates a constitutional right has to be regarded null and void by all organs of state. The German Basic Law provides for, in Article 1, Paragraph 3, quote, "The following basic rights shall bind the legislature, the executive, and the judiciary as directly applicable law," close quote. This makes clear that all provisions in the current German constitution that record constitutional rights are norms that are legally binding. To be sure, things have been less clear in German constitutional history. Under the Weimar Constitution of 1919, in force from 1919 up to the National Socialist regime in the mid-1930s, there was a lively debate as to which kind of constitutional rights were actually binding law and which were not. For the latter, the term Programmsätze, merely programmatic norms, became famous, or one should better say, notorious. Even though such an understanding of constitutional rights is now ruled out by Article 1, free basic law, there are other provisions of the Constitution that do not give rise, according to this or that opinion in the academic literature, to binding law. The temptation to declare legal norms with which one disagrees, for which reason ever, to be not binding, seems to be difficult to resist. Compared to a situation in which there are no legal rights at all, non-binding legal rights seem to be a step forward. They mark, however, only a transitional phase, since the argument from effective enforcement calls for legally binding rights. The expression subjective right is often used without a clear definition. I shall understand this expression as referring to a complex position which embraces at least two elements: a substantive legal position and the legal power to enforce this position before the courts. For example, there may be a substantive legal position according to which there is, in certain circumstances, a definitive prohibition for the state to interfere with attending a certain church service. The individual A wants to attend this church service in these circumstances. We know that the state violates A's religious freedom if A is barred from attending the church service. This usually needs to be established by balancing religious freedom with the relevant limiting reasons. Let us assume that religious freedom outweighs the limiting reasons. This is why the prohibition of interference in this case is definitive. This substantive legal position, according to which A may not be barred from attending the church service, is provided for by an objective norm. Any organ of state definitively acts unconstitutionally if it bars R from attending the church service. This objective norm becomes a subjective right if A has the legal power to enforce the substantive legal position before a court, be it an ordinary court or a constitutional court. This legal power is a procedural legal position that refers to a substantive legal position. A is procedurally empowered to enforce his religious freedom, substantive legal position, before the courts. Thus, the transformation of an objective legal norm to a subjective right is marked by adding the procedural legal position that a person has the legal power to enforce a certain substantive legal position before the courts. The fact that a substantive legal position protects the interests of an individual is a strong argument that this individual also has the legal power to enforce this substantive position before a court. A has a strong interest that his religious freedom is respected by the state. This suggests that it is also him who decides whether to bring legal action or not. What would happen if the holder of a substantive legal position would not be empowered to enforce this substantive legal position before the courts? It would be left to the organs of the state to decide whether A's religious freedom ought to be enforced. The organs of the state do not, however, have an intrinsic interest in enforcing constitutional rights of individuals. It is the core idea of human rights to protect fundamental interests of the individual. Thus, it ought to be decided by the autonomous individual, him or herself, whether a violation of his or her basic right is brought before the courts. This distinction between substantive legal positions and the legal power to enforce these substantive legal positions before the courts is crucial for a proper understanding of debates on subjective rights. Since subjective rights always have two elements, the substantive legal position and the procedural legal position, there are two different kinds of arguments against the existence of a subjective right. Assuming that there is a debate on measures against the COVID-19 pandemic, and a prohibition of church services is justified by reference to public health, the executive argues that A has no subjective right to attend church services during the pandemic. What does this mean? Considering the two elements of subjective rights explained above, it may mean two things. First, there is no substantive legal position according to which A is definitely permitted to attend church services. Or, second, there is such a substantive legal position, but A is not empowered to enforce the substantive legal position before the courts. The statement A has no subjective right to X usually is meant to express that A is not the holder of the substantive legal position in the first reading, position X. If there is no substantive legal position, the issue of whether there is a substantive legal position that may be enforced before the courts does not arise in the first place. There's not even an objective norm according to which, to use the example above, A is definitely permitted to attend church services. To be sure, it is also possible to discuss specifically whether an individual has the legal power to enforce a certain existing substantive legal position before the courts. Specific arguments against the procedural legal power to enforce an existing substantive legal position are, however, quite specific and rather rare. As already mentioned, the existence of a substantive legal position that protects fundamental interests of the individual gives rise to a strong presumption on behalf of the procedural legal power to enforce this substantive legal position before the courts. And this strong presumption can only be rebutted by at least equally strong specific arguments against the procedural legal power. The substantive legal positions granted by constitutional rights and convention rights are typically prima facie positions. For example, religious freedom in the example mentioned above is a prima facie liberty. Such a prima facie liberty can be limited if the formal and substantive criteria for limitation of the constitutional right or convention right are met. If either criteria for limitation is not met, then the prima facie liberty has proven to be a definitive liberty, and the state action interfering with this liberty has proven, in turn, unconstitutional. Or these criteria for limitation are met, then the liberty has proven to be a mere prima facie liberty, which is outweighed by competing rights and goods, and does not, therefore, determine the legal consequence in the case at hand. It has been argued that the interpretation of constitutional rights as prima facie rights renders these rights too weak, deprives them of the special status they deserve. Of course, a definitive or absolute right is stronger than a prima facie right. There is, however, a serious problem if two definitive or absolute rights compete with each other, since by definition both absolute rights must fully take precedence over the other, respectively, which is impossible. To avoid this problem, absolute rights must make sure that such competition does not occur, which in turn makes a very narrow interpretation of absolute rights necessary. At the end of the day, in such a static system, there is relatively little protection of constitutional rights or other basic rights. The strength has turned into weakness. By contrast, if one accepts that competitions between and among individual rights and collective goods occur, a prima facie right can be conceptualized far more generously than an absolute right. The rigidity of supposed absolute rights can be reconstructed by means of very high relative weight attributed to them in the balancing, so that a system of prima facie rights may well contain rights that are more or less weighty from the abstract point of view. Since balancing judgments are taken under certain circumstances and these circumstances change over time, balancing judgments typically may change accordingly. For example, many would agree that limiting church services for the sake of public health must be possible during a pandemic, either before a pandemic or after the pandemic has sufficiently receded, hopefully soon. Religious liberty implies the definitive constitutional right to attend church services. Only the dynamic reading of constitutional rights as prima facie positions explains why there is normally a definitive right to attend church services, while during a pandemic with a certain virus or other certain circumstances, there is actually no such definitive right. By contrast, a certain system of only definitive rights could only assume that either there is such definitive right, which would be very detrimental during a pandemic, or second, that there is no such definitive right, but this deprived the citizens of this aspect of religious liberty before and after a pandemic without any convincing reason. The nature of constitutional rights as prima facie rights, or in other words, as rights amenable to limitation, is the basis for the whole doctrine of constitutional rights and international human rights, developed in Germany and abroad over the last 7 decades. To determine prima facie protection, the area of protection, Schutzbereich, and the interference, Eingriff, must be established. The personal dimension of the area of protection, personeller Schutzbereich, determines who is protected. Who are the holders of this right? Individuals, private associations, corporations, maybe even organs or bodies of the state, if only by exception. The material dimension of the area of protection, sachlicher Schutzbereich, determines what is protected. An action of the holder of the right or a certain state of affairs. Finally, the interference, Eingriff, characterizes against which behavior of the state there is prima facie protection. Only intentional and direct effects of the behavior of organs of bodies of state, or also unintentional, merely factual, and also indirect effects. Once the prima facie right has been finally determined, the issue of justification is at stake. To begin with, is the constitutional right in question limitable in the first place? Is there a written limitation clause, or is the legal power of the state to limit this right implicitly granted? Constitutional rights and convention rights often require that a limitation is provided for by law, which is to say that in the German reading of this requirement, the executive and the judiciary require prior authorization by parliamentary statute, for only parliament is directly democratically legitimated. Formal criteria for limitation include, for example, the legislative competence. A federal law is unconstitutional if the Constitution attributes, in a federal state, the legislative competence to the states and proper legislative procedure. The main substantive criterion for the limitation of constitutional rights is the principle of proportionality, with its 3 prongs: suitability to further a legitimate end, necessity, and proportionality in its narrower sense, the balancing test. It is characteristic of a prima facie right that its application permits and indeed requires balancing. The German debate on constitutional rights has been centered for decades around the main distinctions: area of protection, personal material; interference, justification of interference. it actually proves very useful to have such a general doctrine, for the similarities and differences between different constitutional rights become clear. This avoids the whole system of constitutional rights, and the interpretation becomes inconsistent and incoherent over time. This is a great danger if one simply follows the contingency of an organic growth of case law, with little reflection on the key distinctions in the doctrine of constitutional rights. Now that the four distinctions have been sketched, it has hopefully become clear what is usually meant with the statement, A has a subjective right to attend church service. Being a subjective right presupposes that the right in question is a legal right. This is to say that one refers to an instrument for the protection of human rights, not human rights as to religious freedom as a moral right. More precisely, the statement means that A has subjective and definitive right that is granted by a norm that is legally binding. In turn, the statement A has no such subjective right means, on closer inspection, that A does not have a subjective and definitive right that is granted by a norm that is legally binding. Nota bene. This does not necessarily mean that A's right is not a subjective right. It typically means something different, namely that A's right is not a definitive right, because A's substantive legal position, his liberty, is limited. So that this substantive legal position has proved to be a definitive non-right, or to use the words with the same meaning in this context, a mere prima facie right. This shows that the language we typically use in constitutional law is not very precise. We seem to refer to a lack of procedural power, while actually we want to express the lack of a substantive legal position. This is just one instance in which a more thorough analysis proves helpful in understanding on which we agree or disagree in our debates. And in my view, this degree of analytical clarity is indispensable if we want to provide convincing suggestions how to interpret constitutional rights and convention rights in hard cases. Let me conclude with heartfelt thanks to Arnulfo Daniel Mateus Duran. He has not only translated the papers, but also realized the edited collection with enthusiasm, diligence, and tenacity. Again, special thanks. In some sense, this edited collection is more his work than mine. Thank you very much.
Muchas gracias, profesor Borowsky, por sus palabras, por su presentación, que nos permiten ver las conexiones sistemáticas entre los diferentes artículos, pero también como los temas que desarrolla cada uno de ellos, y no solamente en relación específicamente con la dogmática de los derechos fundamentales, sino la actualización a problemas y a desafíos como los de los derechos fundamentales, subjetivos, definitivos o no, y la pandemia por COVID, que ha surgido además varias veces, no solo en esta presentación y en este curso, sino que ya desde el año pasado se venía presentando. Quisiera agradecerle muy especialmente a la profesora López, al profesor Mora, al profesor Nava, que nos acompañaran hoy en esta presentación y que nos mostraran, digamos, todas las razones por las cuales hay que leer cada uno de estos artículos con tenacidad, como ya lo decía.
With tenacity, as it was said, and thoroughly. And also we have several pending questions for the book. It is also presented as an introduction to a dialogue with Professor Borowsky, a textual and remote dialogue, but also important. I'd like to take the opportunity to thank Professor Mateos, who has been with us since the beginning of this work. And he has been present and working hard with the proportionality test and the visits and his presentations, and also Professor Borowsky's visits and his own presentations. Finally, I'd like to invite you, all the people who are seeing us via social media and the people who are here in person, I'd like to invite you to go over the materials that are in the website of the of the Center for Constitutional Studies. I think this is a good way to understand and approach his thinking and use the tools that he offers for the adjudication in the domestic scope, and also make the necessary translations. And after reading the papers and watching the videos, of course, read his book about the dogmatic of fundamental rights. Finally, I've said finally like 3 times, but finally, this is the finally. I thank you for your participation, your enthusiasm during these 3 classes and the presentation of the book. I think we have learned a lot. And there's a lot to do in terms of the scope and restriction of fundamental rights in general, but especially in terms of the clear challenges and new challenges, like the pandemic. Thank you very much to the workers of the Supreme Court who make an effort for these events to be successful. Nothing could be done without them, and also the people who are with us with the translation. Thank you very much. And finally, the people who are with us in our social media and those who are attending in person, please visit the website of the Center for Constitutional Studies. You can search for Center for Constitutional Studies, watch the videos, read the articles, and please get in touch with us because we are here for you to discuss these topics. And this is the last session. Thanks again, Professor Borowsky, for being with us for the 3rd year in a row. We hope this may continue, like Professor Borowsky's month. March officially will be your month. And thank you very much, everyone. Have a great rest of the day and a great year and week.